Schumann. I'm the co-director of the clinical ethics program through the Center of Bioethics and Social Sciences and Medicine, and on behalf of CBSSM, as well as Dr. Virkler, my co-director, it is truly a privilege and a pleasure to welcome a speaker from not too far away. One of the advantages of our institution is that our depth and our breadth are such that we can truly bring in visionary international forces in the field of bioethics, and we have one of those individuals with us today. So Karl Schneider is the Chauncey Stillman Professor of Law and an adjunct professor of medicine who is housed in our law school. He is truly an international force in bioethics and the intersection between law and ethics. And I think we're all incredibly excited to hear his perspective. Professor Schneider has a fairly extensive background in health law, having written about the concept of autonomy, both as a legal construct as well as an ethical one, and framing how the law has shaped autonomy, informed consent, and decision-making, both from the bedside vantage point as well as from the regulatory and legal vantage point. His most recent work created waves within the field of bioethics, challenging the concept of the IRB as an institution, and whether or not folks agreed or disagreed with him, everyone uniformly agreed that he moved the conversation forward. It's a privilege to invite him today to speak, and his topic will broadly phrased will tackle the issue of informed consent, what that means, and where we should go with it. Without further ado, I turn it over to the professor. Thank you so much.
Thank you, and thank you for that. That is the best short summary of the autonomy book that I have ever heard, and I am quite jealous. It took me 256 pages to say that, as I recall. Informed consent has been a legal duty for over half a century. And it has permeated discussions of clinical ethics for getting on that long, for research ethics for decades. And I am impressed and slightly surprised that another talk on informed consent could draw anybody to a talk. Maybe it's the food, but here we go again. So let me try to suggest, first of all, that I'm not here to talk about informed consent in any of the usual sorts of ways. I want to put informed consent into a context that is radically different from the concept in the context that it is ordinarily discussed in medical ethics and in research ethics, and different from the context that it is discussed in most legal discussions, because I am, by training and by affection, a lawyer, and I am interested in the problem of how law goes about trying to make the world work better than it does. So I want to think about bioethics, or about informed consent, not as a problem in bioethics or clinical ethics or research ethics, but as a problem in social regulation, and a problem in legal regulation. By the way, nobody told me how long I'm supposed to do this.
We have a full hour,
So at 1 o'clock we end, and it would be nice if I didn't monopolize the entire conversation. Oh, that's a very lovely way of putting it. So the interesting fact is that informed consent is actually an example of a very common legal tool, a very common method of regulating human behavior. And that method is what a co-author on a book that I wrote about this. His name is Omri Ben Shahar. What we call mandated disclosure. Mandated disclosure is any legal rule that requires one party to a transaction to give another party to the transaction information for making better decisions in the relationship. So there are, in the state of Illinois alone, approximately 700 state laws requiring mandated disclosure in some kind of situation. And there are an uncounted number of federal laws that do the same thing. Let me give you some examples that you're familiar with more or less and in various ways. The classic example to lawyers is that any time that you buy a stock or a bond or a mutual fund, you are given a prospectus, which is supposed to tell you what you're buying and what the risks of buying it are. And you are supposed to read that prospectus and study it so that you can make a better decision about how to invest. And all of you who are participating in the university retirement program are constantly, whether you notice it or not, being bombarded with information about your choices, which I know you have all read and studied carefully, because your entire retirement depends on how well you make decisions about these investments. And most people make dreadful decisions that produce very bad returns. You've got a real incentive to read those. I see by the age of people here that most of you have bought a house, which means that you've borrowed money. Any time that you borrow money, the federal government usually, and often state governments as well, require that you be given quite a lot of information about the loan. So when you went to the closing, you were given a lot of documents, and you signed statements acknowledging that information had been disclosed to you. When you go online, you are concerned about privacy and the use that information you put online may be put to. And so you have access to a privacy statement. And I know that concern about privacy is real and deep, and that you have all read these disclosures carefully, because they're not all the same at all. And when you go online and buy something, the law requires that you be given the terms of the transaction. So when you go onto iTunes and buy something for 99 cents, you are asked to click your agreement to the terms of the contract in which you are entering. If you should get into too much trouble with the police, they will read you your Miranda rights. This is a legal requirement imposed by the United States Supreme Court, in which the police are supposed to tell you what the terms of your relationship with them are and what your rights are. And of course, in informed consent, the law requires that you give patients the information they need to make decisions about their medical care, and the law requires that you give research subjects the information they need to decide about whether they will participate in the research and on what terms they will participate. Those are just a few examples that just scratch the surface. My colleague found in his search through Illinois law, he teaches at the University of Chicago, that there were hundreds of other more specific kinds of requirements. So, for example, if you should buy a cemetery plot or a casket, Illinois requires that you be told in all caps, there is no scientific or other evidence that any casket with a sealing device will preserve human remains. Okay, so what are the goals of mandated disclosure? The goals are often not articulated very directly, but are easily inferred from discussions and from the extent of the disclosure obligation. The goals are to give the person receiving the information, the disclosee, the information he or she needs in order to make a good decision. And this is thought to be especially important because the usual assumption is that the discloser, the person that the disclosee is dealing with, has interests of his or her or its own that are not the same as the disclosee's interests. So it's intended to free you from the domination of the person or the entity that you are working with. Now, the question that Omri, my co-author, and I asked was whether there was any area of law in which this method of mandated disclosure achieved the goals set for it. Was there any area of law where the disclosure of information by legal requirement led people to make informed decisions? We are still looking for that area of law. We have never found one. We have found little spots where there is some encouraging evidence. But even there, we are not optimistic about how that evidence will pan out in the end. And we also have observed that there is a dynamic of disclosure in which lawmakers constantly expand the range of things that you are required to tell the person you are dealing with. So it can start off with saying you have to post the number of calories on every box of cereal, and then people say, well, if you're going to do that, surely you should tell us what the sodium content of the cereal is, and you should tell us. And the upshot of this is that the entire side of the Wheaties box is information about the nutritional contents of the Wheaties. So complicated that I have to fetch my wife to have her tell me where in all of this the information that I need actually is. So let me give you a few examples of some of the most important disclosure areas, some of the oldest disclosure areas, where the technique of mandated disclosure has not achieved the goals that were set for it. Well, first of all of that stuff that you get online, nobody, now when I say nobody reads it, I mean nobody reads it. The beauty of this, of course, is that we can count the number of people who go to the page where the information is, and nobody goes to that page. Using a measure of whether you are on that page for at least, I think it was 6 or 9 seconds, 1 or 2% of the people who were supposed to be interested in this page ever actually visited for 9 seconds. And my own deep belief is that the people who were there for those 9 seconds were desperately trying to figure out how to get out of that page and back to the page where they could actually buy the book that they wanted. So we know that the privacy statements aren't read. We know that the terms of the contract aren't read. Those are simply ignored, so they can't work. Perhaps the oldest area is of these mandated disclosures is truth in lending laws. And this is an area where Congress has worked really hard for a really long time to make the lender describe to the borrower exactly what the terms are. And Congress had been working very hard on this for about 40 years before 2008. What happened in 2008? Thousands and thousands and thousands of people found out that they had mortgages whose terms were disastrous for them and were predictably disastrous. So one study of consumer credit disclosure says simply, it has not achieved its goals. The Treasury Department, in its comprehensive statement, said, even improved disclosures will not curb abusive and predatory lending. Disclosure of costs does not by itself prevent unfair terms and other abuses, and can have the unintended effect of sheltering predatory lenders. In other words, one of the problems that you get with mandated disclosure in a lot of these areas is that if the lender says, "Dear Ed, I'd like to lend you some money, and I know that you'd like to borrow some, and here are the terms." The terms are essentially that in exchange for $200, you will pay me back $1,000. And this, I'm basically telling you the facts of a real case, although the consumer was rather less sophisticated than my example here. And the Seventh Circuit said, well, this woman was very badly deceived and cheated, but the lender disclosed every single thing the lender was supposed to disclose. She didn't read it, she didn't understand it, and that's her tough luck because the lender did what the lender was supposed to do. The lender disclosed. One of the most famous examples of mandated disclosure, of course, is Miranda. It was once described as the most ignored warning in America outside of a cigarette package. The people who criticize Miranda say it's a bad thing because it keeps criminals from confessing. The people who defend Miranda say, no, it doesn't. Nobody pays any attention to Miranda, so it doesn't actually stop people from confessing. And my authority for this statement is one Yale Camisar who is, Ed will tell you, history's most important defender of the Miranda Rule. Even something as plainly desirable as an ordinance that requires a restaurant to post a hygiene grade in its window has turned out not to produce better hygiene in restaurants. And in fact, seems to be a worse way of dealing with the problem of hygiene in restaurants than lots of alternatives. So it shouldn't be a surprise that when we look at the data on the success of informed consent in medicine and in research, that you repeatedly find that even when you have the most extraordinary efforts at informing patients, and even when you have the most sincere efforts at informing patients in ways that are completely impractical in any real world, that on average, if you give patients a multiple choice test, they will show that they understood about 50% of what they were told. If you give them fill in the blank test, it's about a third of what they were told. And if you look at the data on how real people make decisions about classic decisional problems like treatment for breast cancer, that you find that people are mistaken about a significant number of the elements of their decision. So, and in research contexts, the problems are, if anything, worse, partly because so many of the research subjects can't imagine why they're being asked to fill out all this paperwork in order to be asked some questions about themselves. Now, why does this technique of mandated disclosure get used so much if it works so badly? And the answer is that it's so easy to put into law. It is a way for lawmakers, judges, administrative agencies, legislatures, to say to their constituencies, yes, we see the problem here, and we have addressed it by requiring disclosure. And so, for example, some years ago, a student at a college was raped and killed. Her name was Jean Clery, and her parents felt that had they known how dangerous Lehigh was, that they would never have sent their daughter there. And they put a lot of pressure on, they were able with other people to put a lot of pressure on Congress to act. Congress might well have tried to act in ways that directly address problems of violence on college campuses. But nobody really knows how to deal with a lot of those problems. They're very difficult to deal with, and they're very expensive to deal with. So what Congress did was to pass the Clery Act. So those of you who wonder why you got an email last night saying there was a break-in at so-and-so's house, it is because the Clery Act requires the university to tell students and faculty and staff about the crimes committed on college. And in order that you can make better decisions about whether to work here and people can make better decisions about whether to send their children here, the university publishes annually a statement. Last time I looked at it, it was about 140 pages, which was a report on crime in the University of Michigan. So the pressure to act on Congress was dealt with by passing a law that was passed virtually unanimously, that required no federal expenditures worth mentioning, that spread all of the cost onto other people, but unfortunately has exactly zero effect on the rates of crime and on the ability of people to make good decisions about where to live and where to send their children, because the crime reports are meaningless. Crime is very, very, very difficult to report accurately, and universities and colleges have every incentive, have few resources for doing it well, have bad instructions for how to do it, and have every incentive to minimize the number of crimes that they report. So in fact, the colleges that do the best job of reporting the crime are the ones who report the highest level of crime and therefore presumably deter people from coming to them. Instead, people send their kids to the school that does a very sloppy and dishonest job of reporting it, and that's how disclosure works. But disclosure here was cheap for Congress, responded to a need, and it seems so obvious that if you just give people the information they need for making important decisions, they're going to use it. And one reason it seems so obvious is because we look at these issues through what lawyers have traditionally called trouble stories. That is, we have Jean Clery, who is murdered. How are we going to stop college students from being murdered? We look at it and we say, in retrospect, if her parents had known how dangerous Lehigh was, and I'm leaving unexamined the question of whether Lehigh was actually a dangerous place. My wife's father was the registrar at Lehigh for decades and decades, and I'm not quite sure why Lehigh is picked out as an especially dangerous place, but leave that all aside. If they had known it was an especially dangerous place, surely they wouldn't have sent her there, because look what happened when they did. So we look at these particular instances in which things went wrong, and we say, if people had had the right information, and if they had paid attention to it, and if they had reasoned from it correctly, then they would have reached a correct decision and the trouble story would never have occurred. So if you look at mandated disclosure that way, it looks as though it has to work. And that is, in fact, how informed consent was originally sold. There were stories about people who were treated without their consent. And that seemed so clearly wrong that people said, surely if we inform them, they will make good decisions for themselves, for all of the obvious sorts of reasons. I want to suggest that a large part of the problem with mandated disclosure generally, and informed consent particularly, is that it is based on a misunderstanding about human psychology. What we need to understand this, Omri and I believe, is what we used to call a Gestalt Shift. Is that a phrase that has any meaning anymore? For some. We need to, it's like the optical illusion. It's either two faces or a vase, and once you look at it as a vase, it's hard to see as two faces. You need to make that shift in the basic way that you perceive things. Because if I come up to you and say, how do you use the disclosures that you get on, say, the internet? What I get is stories about how I clicked acceptance to terms that I never read, and that I tried to read and discovered were incomprehensible. Essentially, mandated disclosure is what we sometimes call fine print. Mandated disclosure is a joke at cocktail parties. The iTunes contract, which is a kind of model of this, partly because, as nearly as I can tell, everybody except me has bought something on iTunes, is an excellent example of how this kind of arrangement is supposed to work. Let me give you another example of this. All that information about mortgages that you get that's supposed to prevent catastrophes like 2008. So my co-author, Omri, is a professor of contract law and consumer protection law. He has a JD from Harvard. He has a law degree from a university in Israel. He has a PhD in economics. He can actually understand the disclosures. He can read them. So he recently refinanced his house. The house is subsidized by the University of Chicago, so he was able to afford the very best kind of mortgage, which is to say the least complicated 30 years and you're out, fixed-term mortgage. So it had fewer disclosures than the kind of mortgage that causes trouble. In the process of refinancing, he signed 30 different disclosure statements. Did he read any of the disclosures? Of course not. You're sitting there with the closing agent, the escrow agent. What, if you're going to read all those things? It's going to take you hours. It takes you hours anyway. It's going to take you even more hours. I refinanced a number of years ago. I'm a property professor. I deal in the law of transferring real property. I can understand all of those disclosures. Did I read them? Of course not. No time, too much trouble. Richard Posner is probably the most broad-gauged judge, certainly in America today, possibly in American history. He continues to have an academic output that would impress almost anybody, while he is a federal judge, and he does much more writing as a federal judge than I think almost any other federal judge. So he knows how to read them. Does he read? He recently said, I refinanced my house and I got all these disclosure documents. Did he read them? Of course not. We're the ones who can understand it. If you read them, you couldn't understand them. Partly because they are not written in language that you can understand, but even if you could understand every word in the document, you wouldn't know what it meant because you wouldn't know what consequences it had and what the alternative provisions were. And that's what really matters in understanding this kind of disclosure document. So, what I've been suggesting is that when we look at this from the point of view of the recipient of these disclosures, they begin to look as though they are not going to work. And when we begin to examine the documents further, we see even more evidence that they are not going to work. Now, one of the reasons that they don't work is because they are very numerous. And they are very numerous in any given area of disclosure. As the example of the mortgages suggests. But they are also very numerous in the sense that disclosures about even a single disclosure can be so long that nobody will ever read it. So let's come back to this iTunes contract. And let's imagine that we have printed it out in 8-point font. Okay? As a long-time retina patient, I can't read 8-point font, but many young people can. It's very small. We print out the iTunes contract in this 8-point font, and then we fasten the pages together so that it makes a kind of scroll. This is the scroll. This is my co-author. This is the University of Chicago Law Library. As you can see, the scroll starts at the top of the balcony and comes down, loops around a couple of times and ends up in Omri's left hand. 32 feet. Okay? Why is it so long? It's so long because all of the terms have to be revealed. Now, this may lead you to say, I see now where the problem lies. The problem is that disclosures are too long and written in language that is too complicated, and so what we need is simply to have a rule saying the language of disclosure has to be simple and disclosures have to be brief. And that is in fact what the federal government has said by statute and administrative regulation over and over again. OHRP, when it's regulating IRBs, speaks very sternly to them and says you must be sure that researchers' disclosures are written in simple language and that they are not too long. Why then, when we look at research disclosures, do we find that they keep getting longer and harder to read? Research disclosures are specifically checked by IRBs. So we have a regulator right there who can say to the wicked researcher, you are failing to write simple disclosures that are brief enough for people to use. If disclosures keep getting longer in the IRB context, what are they going to do in this context where there isn't anybody to look over the individual disclosures? In fact, the model disclosures that IRBs use are unreadable by almost all of the country. They are written at a level far beyond the ability of most people to understand. Those are the examples that IRBs use of how you ought to disclose things. So, what is the problem that leads even the regulators to do such a bad job of getting things said simply and directly? And part of the answer to that is you only need to mandate disclosures when the problem to be dealt with is a difficult and complex problem. You cannot explain difficult and complex things simply. First of all, there is the language problem. You have a choice. You can use the professional vocabulary for describing the problems. Professional vocabulary essentially reduces complex ideas to a single term. In law, the term res judicata has quite an elaborate and specific meaning that only two other people in this room understand. But for us, why not just say res judicata? In medicine, the problem is obviously much worse, and you know much more about it than I do. So if you try to avoid the professional vocabulary, you're going to have to spell out the meaning of all of those terms, and that's going to make the document long. And when a document becomes long, it becomes hard to understand just because of its length, and it becomes repellent to readers just because of its length. So part of the problem of simplifying disclosures is that you have something complicated to explain. It's important that people understand all of the elements, because if they misunderstand one thing, they can make a bad decision. So you are constantly trying to find some happy medium between full disclosure and simplified disclosure. And it is a resounding fact that people with the best skills at doing this and the best incentives for doing it have failed for decade after decade after decade to find the right language for writing disclosures about mortgages, about lending, about you name it. I think that when really smart people have worked for a really long time at doing something and have repeatedly failed, that you need to start asking whether what they're trying to do is possible. And stop admonishing them when they don't succeed. So that's part of the problem. Another part of the problem is that we tend to think about these disclosures from Ann Arbor and from a very carefully selected part of Ann Arbor, which is part of Ann Arbor which is unduly supplied with people what are ominously called terminal degrees. If you look at the level of literacy in the country, you will find that a large part of the country is going to be unable to understand disclosures unless they are extraordinarily simple. To reach the 80th percentile in literacy, all you have to do is to be able to understand the definition ordinarily given to jurors to explain to them what a peremptory challenge is. Okay? You don't have to know what peremptory means. You have to be able to understand the definition of a peremptory challenge, which is a lawyer's ability to disqualify somebody from a jury without explaining why. 80% of the country cannot understand, cannot read this very commonly used description. And the country is much less able to use numbers. As many of you probably know, there is a simple 3-question test to try to evaluate numeracy. I am one of the least numerate people I know. I first encountered the test when I was reading it upside down, and it seemed painfully simple to me. It turns out that only 16% of the country gets all 3 answers right. And, in fact, in these areas that we're talking about, medicine, finance, Miranda, the understanding the disclosures, even if you can understand the language, really requires what I would call sector literacy. You can't really understand a lot of medical disclosures unless you understand a lot of the assumptions that go behind them and a lot of the ideas about how the body works and how medicine, how drugs work and so on. Same thing in law. There's been a real problem with the financial disclosures. People don't understand what it means to borrow money. So the almost universal answer to that is we should get better education in these sectors in high school. But the high schools are the same organizations that can't produce literate people. And the more you ask high schools to do, the worse they will do everything. And the evaluations of the success of things like financial literacy training are that they do not make people better informed decision makers, and there is some evidence that they make people worse decision makers because they equip them with little information but a lot of confidence. So, I have lots more to say in explaining to you why mandated disclosures should not be expected to work, so that it should be no surprise that they don't work. Work, meaning, again, achieving the goals set for them. Omri and I wrote a book about this called More Than You Wanted to Know. And I, as a law professor, am set to run for 55 minutes in describing these sorts of things, and I'm happy to do that. But I have learned over time that the only way of actually ending when you're supposed to is to stop. So I'm just going to stop in what my classics friends would call in medias res, in the middle of the thing, and let people postulate or ask questions or do whatever the Spirit moves them to do.
I have two questions about the goals of mandatory disclosure.
Mm-hmm.
Is it simply, does it become something else if we're trying to persuade people to change their behavior? So if we, instead of disclosing the Surgeon General's warning on smoking on the cigarettes, we put a picture of blackened lungs, which is maybe emotionally persuasive. Is that a form of disclosure? Is that something else? That's a different conversation.
I think that's really a different kind of conversation because your job is much simplified. You're not trying to describe, you're not trying to give people the information to make a completed decision. You're trying to inveigle them into changing.
And that's harder.
Those things don't work very well either, but it's a different discussion.
Sometimes they work. You do it.
Well, I've recently been looking at the literature on obesity and exercise. And partly because one of your colleagues here said to me, "So, Karl, you should lose weight and get more exercise." And I said to him, "Come on, Jim, we both know that advice doesn't work. That the chances of my losing the weight and keeping it off are virtually nil." And then to make sure I was right, I went and I read all the literature, and it turned out that I was even more right than I thought I was. But Dr. Johnson once said that a second marriage was the triumph of hope over experience. So I've lost 40 pounds and exercise 3 times more than the government says I need to. And I am, like many people, persuaded that I am going to be one of the few people who eventually is allowed to join the NWCR. the National Weight Control Registry, which I do by losing 30 pounds and keeping it off for a whole year. But I know what the failure rate is, and I have a sense of humor. So
my second question though was, I'm sure you've looked at this and been asked this many, many times, but some people argue that that long sheet of paper there doesn't help the consumer at all.
Right.
What effect does it have on applicants who have been forced to be transparent about all these things? I think I know what you would say, but just one thing.
Well, Omri and I actually have browsed through this, and our conviction is that the people at Apple haven't read it either. It is completely loaded with typographical errors and other things that suggest that even the lawyers who had to draft it, and they didn't do this because they wanted to, they did it because they had to. They didn't read it very carefully. When I bought my iPad, I said, because I had the sense of humor, to the woman who was selling it to me, when she presented me with all these terms, I say, so can I negotiate about these? And she said, well, somebody wanted to once, so we told him to read all the terms and then he could contact the main Apple office. I don't know quite whom you contact at the main Apple office to do this, but of course it doesn't change Apple's behavior, partly because the way that Apple deals with you isn't going to be by consulting that. How Apple deals with you depends entirely on how good their customer service department is. And you can't afford to litigate that, and they can't afford to litigate that. You're not going to settle it that way. The real issue is Apple a good company to do business with? So if what you want is disclosure that people actually use, I suggest you go to Amazon, where you get real human beings writing reviews of products where they say, this is what matters to me about the product, and this is how well this product worked. I used it for 3 weeks and it broke, and I called the customer service department and they told me to get lost, and I'm never buying one of these things again. Or, for those of us who do woodworking, you get first a review of the table saw that says, the safety guard doesn't work very well. And then you get a comment that says, yes, but that's because clearly this person who made this comment didn't read the manual carefully enough, because the safety guard doesn't go there, it goes there. And so you get quite a learned discussion. I like Handel oratorios, and I read the Amazon reviews because you have extremely learned people saying, now there are 4 different versions of Judas Maccabeus. And if you like the Paul McCreish style, more ancient instruments and all the rest than this one, but its chorus isn't very good. So you get people who use the product talking to other people who want to use the product. And it's not the disclosure that the law ever wants, but it is the disclosure that people who use it want. On the woodworking equipment, for example, they're very good about telling you how to get the saw into your basement without telling your wife. Which is information that has a very high utility. So I'm not against information. I'm in favor of information. I'm a professor. I teach people how to do things. And I have to say that being a professor of the kind that has to grade examinations every year, I am amazed that anybody thinks that a conversation with a patient is going to convey information that works. Because my students are some of the ablest students in the country, specially selected by the LSAT for their ability to learn law, which requires a particular kind of mind. And they are now older than they used to be. They've been out of college for a while. They're very serious. They work very hard. They're very scared. They know that jobs depend on how well they do, particularly in the first year of law school, which is what I teach. And I have spent 35 years trying to understand how to help people learn legal doctrine and legal analysis. And when I get the blue books, what psychiatrists used to call melancholia descends in the Schneider household. My wife basically buries her head for 3 weeks while I grade blue books. It's a disaster. They don't get the basic legal doctrine right. Now, if that kind of student with that kind of time and ability and help has so much trouble understanding complicated things, is it any wonder that mere disclosure is such a failure? You?
There was a sociological component to informed consent. Schoenberg case, people, sound mind, blah, blah. And the idea was stop making people subservient. Stop saying, I'm the doctor, I know everything, you know nothing, I'll tell you what to do, you'll do it. To what extent can you build that in without a mandated disclosure?
I think that one thing that's hard for laymen to understand is that just because you have a problem doesn't mean that you ought to seek a legal answer for it. And it doesn't actually always mean that you have to do something about it. Attitudes toward what we used to call medical imperialism have changed radically. And one place where they've changed radically is in medical schools, both among the people who come into them and in the people who teach in them. And what patients are willing to put up with in terms of medical imperialism has changed socially. And I would suggest that informed consent is more, as a legal matter, is more a result of changing social attitudes than this changing social attitudes are a matter of law. Let me just add something here, because it seems to me to be a reasonable question after I've said, stop listening to the people who have these legalistic, formulaic ideas about consent. So you're a physician, what should you do? And I think that the answer to that is an answer dictated by the relationship between doctor and patient, where you have doctors of a huge variety and patients who are every single person in the country. And that means that these interactions are going to be highly idiosyncratic. When I work with physicians here as a patient, I've been almost with there was a surgeon once with whom I had some difficulty. But otherwise, I've been very happy because I have felt that the physician was trying to find a way of working with me to reach a satisfactory result. And what that often meant was not that we dwelt on the decision, it meant that we tried to figure out what we could do to make me healthier. So a lot of this time in discussion was not spent saying, how are we going to make a decision? It was, how can I help you maneuver yourself so that you can lose 40 pounds? And I think that what patients want is much more likely to be that kind of help than the, here's the information. And I've always thought it was kind of insulting to insist that patients make decisions. I remember an endodontist I was sent to who gave me all the information that he got from examining my tooth. And I said, so do I need a root canal? And he said, that's your decision. And I said, yes, I actually teach this stuff, and I know that it's my decision, but do I need a root canal? And he said, no, it's really your decision. And I sighed and I said, well, okay, so if it were your tooth, what would you do? And he said, well, my values might be different from your values. And so what I would do is irrelevant. And I thought that was insulting because I had told him how I wanted to make the decision. And he wouldn't let me do that because he thought he had a better way that I should make the decision than I did. And furthermore, on examining my values, I found that none of them spoke to the question of endodontics. So I must say, I think there is a lot to be said for trying to work with the patient in the way that seems to you as experienced clinicians the best way to do it, and not to listen to people who want to turn this into a question of philosophy or law. You have 12 seconds. Okay. Thank you very much. I appreciate your coming. You've been a very good audience.